Dear ICCS members and friends, good afternoon and welcome to this webinar session on intellectual property Insight News. My name is Carola Capone and I'm the Marketing Executive at ICCS. Welcome everyone once again. I would like to introduce you to today's speakers. Connecting with us today, we have Michele Ferrante, who's the Managing Partner at Ferrante Intellectual Property, and Marta Giordano, Managing Director at Fidinam Singapore. Before leaving the virtual floor to Michele Ferrante, who will start today's conversation, I would like to remind you all that if at any point you would like to ask any kind of questions to our speakers, you can do so by typing in the Q&A box below, and then we will address these questions at the end of the webinar. Thank you, and I shall now leave the word to Michele. Michele, you're still unmuted? Okay.
Okay.
You? Yes.
Here you are.
Yeah.
So just to give you today we are going to talk about intellectual property in China, in Vietnam, and Singapore. Maybe we go into the summary. First, I will briefly introduce myself and our firm, just so you know. Our firm. We are a full practice intellectual firm. We have office in Beijing, Shanghai, Hong Kong, and we have cooperation with the firm in other Southeast Asia countries, Macau, Vietnam, and other countries. We are focused on IP, so we do a prosecution of trademarks, patents, and copyright, criminal, civil, criminal, administrative lawsuit for the protection of all the rights connected to IP. And we assist our clients in the Asian region to the protection of the rights in relation to the sale of counterfeiting goods or copies. And we have investigation program, and we work a lot with customs in different countries in Asia. Myself, I've been founded the firm in China in 2003. And since 2009, I've been working on a Chinese case, assisting a multinational company in different sectors. I've been a speaker in many different conferences and seminars, and I've been participating to many meetings in different countries for the drafting of the laws related to the protection of IP. So going to, thank you. So first of all, what we can consider IP, intellectual property? So everybody knows trademark. Every sign will see what is copyright, patents, trade secret, geographic indication, and domain name. All this is considered are actually property of your mind or property knowledge, and they are related to ideas and creation of the mind, and is considered an valuable assets for the business and for the companies. In particular, with the evolution of the business in relation to e-commerce and other distribution through internet, the IP is becoming more and more important, and all related to everything related to the rights, as trademark, copyrights, and patents becomes very important assets. All the IP rights can be sold, both license and pass other form of contract, and can of course be used as a factor to pull in investors as an asset, valuable asset of a company. So for this reason, it's very important to protect from the registration level. So first you have to register your rights, and after protecting for combating counterfeiting or any other violation of your rights. So let's see what is a trademark. Everybody knows what is a trademark, but just to clarify, there are different kinds of trademarks. So for sure, the wordmark, like FedEx, for example, device, like for example, Puma, but we know many other devices like Nike, Adidas, Armani, the Eagle, another device. Combination, so it could be the combination of wordmark and device, like in this case, the Metro-Goldwyn-Mayer brand, or a 3D, like the Coca-Cola bottle that is, for example, is registered in China as a trademark. In some countries, also perfumes and sounds can be registered. For example, the noise of the engine of the Harley Davidson is registered as a trademark in some countries. Talking about copyrights, the copyrights originally was more related to protection of all the creation related to arts, so books, written works, design, paints, sculpture, and musical creation, movies, radio program, or other performer, like for example, the theater exhibition. Nowadays, in some countries, in particular in China, in Vietnam, this protection has been extended also to design products. In particular, if you think about design products that are actually originally more protected with design, I mean patent registration, but are nowadays the ones awards, or for example in museum, example of modern design. In this case, the protection is extended also to these products. Talking about patents, patents is more related to invention or design. So this is related to process of manufacture, new technologies, and methods that can be protected with the registration of the patent. Is a patent invention, we'll see later in different countries, generally is 20-year protection. If it's the design is 10, 15 years, depends the country. One of the conditions very important to keep in mind is that the patent has to be new, so it cannot be disclosed before or published before the registration. So if you want to protect your design, for example, you cannot publish before the protection. If not, the design is not valid. Trade secret is another very important element, and this could be used all the time. That, for example, you have a recipe, for example, and you don't want to disclose, because as we were saying, the longer that you can protect with a patent is 20 years. So some companies like Coca-Cola, KFC, W40, they opted to keep their recipe secret instead of registering and publishing. So after many years, they keep holding the secret and not disclosing. These secrets are protectable under some condition and in general due to a specific law. And of course, also in this case, it has to be secret and kept under some condition. Talking about China, what are the rights that we can protect in China? So, of course, trademark can be registered. It could be a word trademark, device trademark, combination mark, three-dimensional trademark. So, for example, the bottle, as I was saying, and the other, for example, some car producer, they register as trademark part of the cars, and also sounds and perfume. So this is very important when you have, for example, a package of your products particularly distinctive, so you can register the trademarks. For example, Ferrero owns the trademark in China for the Kinder eggs, but also for the Ferrero Rocher. And this is very valuable because you can combat and stop all the producer of similar goods, although they reproduce a different word trademark on the product. Copyright can be registered. It is interesting that copyright could be used to protect also some industrial product where there are some let's say, artistic components that are important, like, for example, design products. In case you haven't published, you have published the product before filing the design, you can protect through a copyright. Patents, as I would say, design patents is after we see trade secret is very important. It's a specific law, but it has to be, the secret has to be kept under some condition. And this is very important also to specify in the contract with the employees that will know the secret, how to deal with it, so with some specific clause. Geographic indication, this is an object of an agreement between China and Europe, we call 100 plus 100, so where China agreed to give a special protection to 100 European geographic indication, and on the other hand, Europe agreed to give special protection to 100 Chinese geographic indication. Domain name and other aspects related to the creation of the mark. So, how to register the trademark in China? Well, you file an application. The application goes through examination where the trademark office will check that there's no previous similar trademark registered, and they check that the trademark is not against law and other aspects considered by the Chinese laws against the Chinese trademark system. It will be published. We publish for 3 months. If nobody opposes the registration of the trademark, meaning someone that recognizes the trademark as a violation of his own trademark, the trademark will be registered. Generally, this registration process is quite fast. Now it's between 6 and 9 months. Imagine that only 10 years ago was probably 5 years. So it's a very, China did a lot of work and move in the right direction in terms of organizing its IP system. Is a first to file principle, meaning that once who managed to register first has got an advantage in keeping and protecting the trademark. And this gives us a lot of problem when we have to cancel trademarks that has been registered by a third party that, for example, a trademark of a foreigner company that has been registered by a Chinese individual or Chinese company. The foreigner company will have more problem to have the trademark back, because the system recognize first who registered first. Is it true that with the last version of the trademark law, this principle has been reduced with the introduction of bad faith and other aspects that for sure will give the possibility, more possibility to foreigners, rights owner, or trademark owner, to combat the phenomenon of scamming or registering trademark in bad faith. It is possible to do a search before filing the trademark to check if there are other similar trademark. It is, if the trademark is new and you never used before, it is a good idea to do it. If it's a device trademark, it's difficult to do this kind of search. If you've been using the trademark in other countries for many years, probably the best option is to register, to file and combat and protect your trademark. The protection starts from the registration, and we see this difference with the Vietnamese and Singapore system. Very important to know that if you have the trademark registered in China through an international trademark application through Madrid Protocol or Arrangement de Madrid, you have to obtain a what we call a confirmation certificate. That is basically the certificate of the international trademark translated in Chinese, but this has to be issued by the Chinese Trademark Office. Nowadays, it's quite operation that is just administrative and is quite fast to obtain the trademark, but it's important to know this aspect. If the trademark is not being used for 3 years, a third party could start an action for cancellation for new use. It is important to know, in case we have a trademark and use actionate the trademark against an infringer in China, to make our evaluation in case the trademark has not been used, because one of the first reaction that the infringer might do is to try to cancel the trademark, and basically the rights owner will not have a base for the action anymore. It is important to, once you register the trademark, to try to use it similar as possible to the version that you have registered. And in case there is substantial modification, probably better to proceed with a new application, new registration, in order to avoid problems in terms of non-use cancellation, but also in terms of enforceability in the moment that we want to combat the use by a third party of our trademark. It is important, very important, once we enter in the before entering the market in China and contacting different partner, to file an application for the Chinese version of the trademark, because the market, the media, the consumer, and your partner and distributors will create a Chinese version for sure. They will not use the original Roman character version. So it is important to create your own Chinese version. In this way, you avoid that the market create one or more version, and makes things more difficult for you to protect, register and protect. I had a client who once came to me and they say, we would like to register a Chinese trademark version, but we know that someone is already using a Chinese version. So we checked, in the end we had to register 10 different versions of the Chinese trademark. That means that you have filed 10 applications, but after probably you might have a different action to protect in case of refusal or opposition. So doing this on time will save a lot of time and energy. So, as I was saying, copyright in China, it is possible to register a copyright. So I have a Chinese copyright certificate, which is very good once we want to start an action, because the Chinese authorities will easily read the certificate. So it is advisable to file an application and obtain the certificate. And the validity of the copyright is, in case it is registered in the name of a company, is 50 years from the creation of the art piece. And in case it's a person, 50 years from the death of the author or the person that is in the title, the owner of the copyright. So this is I mean, if there is a person that can be registered, is of course the protection is got a longer period. As I said, the invention patent, it can be registered in China through the Patent Cooperation PCT, so international system, or through national system. The validity is 20 years. It has to be new. China required that is absolutely new, so there's no any option or any possibility to start publishing and in a certain time or limit time register it. It has to be new. So in this case, we for design, for example, we have a very important case involving Land Rover, that the Land Rover found the Chinese company presenting actually to the Guangzhou Automobile Fair identical car to the Range Rover Evoque, and when they start the action to invalidate the design patent of the Chinese company, the Chinese patent office invalidated the Chinese company patent design, but also the Land Rover one, because the Chinese company managed to show that Land Rover presented the car 1 year before the filing of the design. So the design was not valid. So it is important when you think about China to and design to understand what are the products that might be more interesting for you before presenting, more interesting for the market, and so file the design before they are presented to the public or published somewhere. Trade secret, as I said, it is important to review what are the conditions that the laws require to consider some information in trade secret and keep it and in a certain way, like for example having a special room with limited access to the employee, and mentioning in the contract with the employee some conditions, some clause that limit the possibility for them to disclose the secret, and there's a lot of conditions. So this is very important to do it before starting the activity in China as producing or distribution, because once the secret is public, of course, it is not considered anymore trade secret and cannot be protected anymore. Okay. When we talk about IP, I mean, I would like to clarify that the IP is an object of many international agreement and cooperation treaty and international convention. So the protection of IP in many countries has got many points in common. Of course, after when we go down the detail of the practice for some actions, there are some differences. So today I try to underline few differences there are between different countries and try to, of course, give you an idea. Of course, 20 minutes speaking about IP in 3 countries is very tight, but at least we can underline some aspects. So also in Vietnam, of course, you can register trademark, copyright, patents, design. The trade secret is protected, the geographic indication are protected too, and varieties are protected. So the main difference with China, you cannot protect three-dimensional trademark, perfume, and sounds. And it's also Vietnam is the first to file a system. You can claim priority. So if you file the trademark in other countries under some condition, you can use the dates of the first application. The registration, it takes a bit longer because it's up to 1 year and a half. The validity is 10 years like China. The main difference with China is that China, the validity, the protection of the trademark starts from the day of the registration, where in Vietnam starts from the date of application. So and this is a very big difference because you go and you file, and from that date you are protected. In China, you have to wait, the trademark is registered. It means if someone opposes the registration of your trademark, you might have the protection after 1 or 2 years, it depends, different degree of appeal. And the other difference with China, the trademark can be cancelled after 3 years. In Vietnam, after 5 years. The other particular aspect is that in Vietnam, after the application, the Vietnamese trademark office will publish directly for will publish the trademark, and after we do an extra-stamping examination, and if no problem, we'll grant the registration. Okay, in relation to the copyright, it's very similar to China, so it's available to register. Invention patent is similar, is the same. Design is part of the patent invention. The validity is split, I mean, it's 5 years, but it can be renewed another 5 years, so it's, in total it's 15 years like in China. For the trade secret, also, as I was saying, one of the main conditions is to keep the information secret under some condition. This should be reviewed and considered in this specific matter, very particular care. Okay, for in relation to Singapore, we can, as you can say, we can go to the next slide because the rights are the same. Is also Singapore is first to file system. You can claim priority. The registration is fast as in China. The validity is always 10 years. And also in Singapore, like in Vietnam, is the protection is from the filing date. And as in Vietnam, the trademark could be cancelled after 5 years. And in the process, you file the application, there's an examination, a publication for opposition, and granted registration, like in the Chinese system. Another main difference with Singapore, you cannot register the copyright, so you have to base this on an international convention, it's a Berne Convention. For invention patent, design patent is like Vietnam and China, and so the total design patent is 15 years, where the invention patent is 20 years. For the trade secret are protected a limited period of time, as I was saying, and you have to avoid that becomes public, of course. Let's go to the next. Okay, try to yeah. So these are the different actions that you can internet. So this is you can every platform, Alibaba, Taobao, eachnet, different JD.com, they got a different system to combat the sale of products. So the rights owner can proactively take down the links. There are some administrative action. There are authorities that seize the products in the market. You can do a civil action based on, of course, trademark law, patent law, and copyright law. And for under some condition, you can proceed with criminal action. The police, the Chinese police, is very active in the moment that the case is, the infringer reach a certain level of business in terms of value of the business. And the Chinese custom, they are very active, and the particularity of the Chinese custom that they do in a control in exportation. Okay, so Vietnam mainly is also in Vietnam. You can do administrative action, civil action, criminal action, and custom. The administrative action are the most common because are the fastest, cheapest, and they obtain better results. Okay, let's go to Singapore. So, okay, Singapore, they don't have an administrative authorities to protect the IP, but civil and criminal action are very effective, and custom, they are very good. Also in Singapore, they got a very good arbitration center, the international center, that could be used in case in your contracts with the other party, or you agree with the other party to use an arbitration to resolve your dispute. Okay, this is just a case I brought in China. I don't think Burberry has done anything yet. It is very important to keep, keep an eye on the market and on the internet in all countries. Work a lot with the custom in order to avoid that a third party take advantage of your rights and make a business on the investment that you made previously on your IP rights. It is important to say that if you manage, better to act timely and on time, because more a business, you leave an infringer producing and selling products, it might be that they have a success and their business grow up. and after will be more difficult to stop because they have, of course, the resources to combat and defend themselves. I think, okay, this is another aspect of the case. Okay, as actually said, the increase of sale online lower Burberry market share. So it's very important to combat, because if there is some, let's say, competitors or lookalike, we have many cases, it is important to combat and stop this as soon as possible and avoid that the infringer business become bigger and bigger and create a problem to the original products market. Okay, thank you. I'm very happy to answer your question at the end of the presentation. I think there is already a question.
Yes, we can address that questions maybe at the end in the Q&A session. And now we leave the word to Marta Giordano so she can continue with the presentation first. Thank you, Michele, for your contribution.
My pleasure.
Well, thank you, Michele. Thank you, Carola, and the Italian Chamber of Commerce for hosting this event. Before jumping straight into the chat related to intellectual property, which will be mainly focused on Singapore and the role that the Lion City is going to play in this new environment, I'm going to share with you a few information about Fidinam and who we are. Okay, can you see the slide?
Yes, we can.
Thank you very much, Carol. Well, Fidinam Group is a professional consulting firm with headquarters in Switzerland and offices in 12 jurisdictions across Europe, the Middle East, and the Asia Pacific region, and of course a wide network of professionals and correspondents that we partner up with in order to be able to assist our prospects and clients all over the world. The core business of our activity is mainly in providing professional consulting services, which cover, I would say, a full spectrum of service from market and research to corporate and compliance consulting, tax, accounting, payroll, immigration, digital, and real estate consultancy. Well, having said that, let's jump onto our main topic for today. Michele was, I would say, super clear when he already told us that IP is pretty important, and this IP, intellectual property, is becoming more and more important as a strategic asset and driver as a driver to profitability, and it's quite understandable why. I mean, IP rights are important creators of value in a knowledge-based economy. In the world we are living in, as Michele also said, more and more multinational, but also SMEs are basically shifting from brick and mortar business to online business. And in this environment, we see an increased awareness and usage of different forms of IP rights, which has led basically to the business to start protecting their intangible assets, investing in R&D capabilities, developing brands, technical abilities, and know-how. And why? What's for? Basically, to be able to stay ahead of the competition. And this is a concept that we can apply, of course, to businesses, but we can apply also to government and jurisdiction. And it's pretty important because we can link this concept and we will understand and talk about it when we get to talk about the role that Singapore is playing in this new environment. Pretty important is therefore the ownership and the use of IP within groups, because this is going to affect not only the enforcement of the legal rights, but also the tax and fiscal aspects of the business, I would say. Let's think of group and corporate group transacting in with transaction in IP, this will create, this could create tax issue, like for example, transfer pricing, and these issues are becoming more and more complex when the IP ownership is basically separated by the IP use. In this kind of new environment, basically, companies need to be quick and adapt to changes in the global tax rules, as well as government. As I said, we will talk about the IDI incentive in Singapore, which was first announced with the budget in 2017. And again, the government, in order to implement these incentive and to meet the requirement of the OECD, the Organization for Economic Cooperation and Development, when we talk about base erosion and profit shifting project, needs to amend the regulation. So this is something that not only, as I said, corporation, but also government need to be quite fast in adapting and agile in adapting to. Now, the question I asked myself while I was thinking about intellectual property is, well, where Singapore is placing itself in this picture? What's the aim of the Lion City? Well, it's, I would say, crystal clear. Target 2030, Singapore aims to become a hub for IA and IP transactions and activity, as well as top-ranked IA and IP regime. We all know that Singapore has advantages like strategic location, political and economic stability, efficient tax system with government grants and incentive. So I personally do understand why the Lion City aims to become a leader in intangible asset and IP expertise and service. And the goal is to become the Silicon Valley of Asia. Now, let me give you a couple of numbers linked to Asia and the role that Singapore can play in this field. In 2017, Asia accounted for more than 45% of global gross domestic expenditure on R&D. 65% of the all patent application worldwide in 2019 came from Asia. In this picture, Singapore's already in 2016 capital stock related to intellectual property products grew to around 25%. And if this is not enough, let's think that Singapore was ranked second globally and top in Asia for having the best IP protection system in 2019. So I would say that the strategy that the Lion City and the government has is quite clear. Strengthen its position as a global hub, and the main focus is on three areas: supporting international activities, attracting and growing innovative enterprises, and build a high caliber workforce. So hub, jobs, business, basically. Now, how the government can put in place and implement this strategy in order to reach and hit the goal in 2030, where two different kind of action. One is the one linked to the tax and fiscal aspect, grant incentive, applicability of withholding tax, lower withholding tax rate. The other one is, first of all, by reviewing policies to support emerging areas such as AI, artificial intelligence, and big data, by becoming a node for Asian and the world, so facilitating regional interoperability of IP system and strengthening the connectivity between ASEAN, and the rest of the world. Let's not forget that Singapore took part in several initiatives to help IA and IP owners take their innovation to the global market, as well as Singapore has formed patent prosecution highway, which is a work sharing arrangement with the 5 key IP markets. We are talking about USA, Europe, China, Japan, and South Korea. established patent re-registration program with Cambodia and Laos. And if it's not enough, several international organizations and enterprises set up their regional offices in Singapore. Then I would say that all these factors, all these aspects reinforce the Singapore position as a hub for the IP community and businesses. As said, you can see Singapore is connecting a link to 38 other offices via patent work sharing arrangement. We are talking about ASEAN, and we are talking about Global Patent Prosecution Highway. The other aspect that and other action that each and every government can put in place are related to the fiscal aspect of this matter. Well, when we talk about IP, at least it comes first to my mind, the concept of royalties and withholding tax. Well, Singapore, as other countries, I mean, Michele was talking about Vietnam and China, give a concession. Basically, royalty payments are subject to a rate at 10%, withholding tax rate at 10%. Let's bear in mind that the corporate income tax in Singapore is 70%, so the statutory rate is 17%. Of course, it's pretty important that this non-resident company, this payment made to non-resident company who are not carrying on any business in Singapore and does not have any permanent establishment in Singapore, otherwise the corporate tax will be applied. And always remember that this 10% might not be the rate that is going to be applied because there could be lower treaty rate due to DTAs, so double taxation agreement. Vietnam and China is the same. 10% of withholding tax is applied to royalty paid to foreign entities for the right to use or for the transfer of IP, transfer of technology or software copyright in Vietnam, as well as in China, which is lower from a 20% statutory rate. But I would say another action that the government is taking is the one in order to promote business R&D and encourage the economic growth and innovation is mainly focused on grant and incentive. Well, when we will talk about the IDI incentive, this is not an easy path to walk through because it's pretty new and is quite complex in the implementation. But writing down allowance, which is a grant for intellectual property, so basically allowance are granted on capital expenditure incurred in acquiring IP rights, has been extended in budget 2019, and the basis period has been extended to YA 2025, year of assessment 2025. Well, writing down allowance can be applied to patents, copyright, trademarks, registered design, geographical indication, and so on and so forth. The most important things and the things we have to pay attention to is that capital expenditure exclude legal registration fee, any kind of cost related to the acquisition of the IP rights, as well as stamp duty. But how to apply? To be eligible to apply, it's pretty important that the legal ownership and the economic ownership of the IP rights is transferred to the transferee. And when I talk about legal ownership, I mean the legal assignment of the IP rights is granted to the transferee. When we talk about economic ownership, I mean the future economic benefits attributable to the IP rights will accrue to the transferee. How to calculate these allowance? Well, first of all, it's important that to highlight that it has to be done when the company file is profit tax return with IRS. Basically, at that moment in time, each and every company who wants to apply for this allowance need to make an irrevocable election through a declaration form, where they are gonna state which is the claim, over which period is going to be the claim they're looking for, 5, 10, or 15 years. So let's say the capital expenditure are 450K. If the company opts for 5 years, then the allowance will be 90K per year, otherwise 45 or 30K per year if it is 15 years of period. Of course, it has to be granted, and together with the declaration form, which has to be filed when the irrevocable election is claimed through the income tax return, an independent evaluation report has to be submitted together. Attention to the disposal of the IP rights. Where the IP rights come to an end, or when a company chooses to carry on the trade or business for which the IP rights were acquired, then no writing down allowance shall be granted, not at all, not for the years in which the event occurs, and not for any subsequent year. The incentive, well, incentive is a bit tricky, I would say, because the intellectual property development incentive, as I told you before, was announced in budget 2017. And this year, in January 2021, the government had to amend the regulation in order to align with the requirements specifying the OECD report, BPS and BPS 2.0. The introduction of this kind of incentive basically follows the amendment made to two scheme and incentive that were granted before, the Pioneer Certificate Service and Development and Expansion Incentive. What happened basically is that the IP, these incentives were amended to exclude the IP income from the scope of the incentive itself. Problem with this IDI, which basically is gonna grant a concession on the IP income, basically a percentage of qualifying IP income is taxed at 5% or 10%, is a new regulation, pretty complex and not really straightforward in its implementation. And this is why it's pretty important that, first of all, companies put up in place a system and process in order to be able to identify, track, and de-qualify IP income and IPR. Qualify IP income under the IDI basically refers to royalties or to other income receivable by the approved IDI company as consideration for the commercial exploitation of an elected qualifying IPR, so intellectual property rights. Intellectual property right in this kind of situation, we are talking about patent, application for a patent, copyrights subsisting in software, or a family of IP rights, which means two or more IPRs linked together, interlinked. Only these kind of intellectual property rights are the one we are talking about when we discuss about intellectual property development incentive. How to calculate the percentage of qualified IP income? Well, OECD has given us a formula. So qualifying expenditure times 130%, which is a fixed coefficient, divided qualifying expenditure, which include R&D carried out directly by the IDI company, the one who's applying, qualifying outsourced R&D, or payments under cost-sharing agreements. And D is a non-qualified expenditure. Basically, this nexus ratio means to start, like, it's focused on establishing a nexus between the cumulative expenditure and the income associated. As I said, it's not straightforward at all to apply for this incentive, and this is why also consultant always try to seek with IRAs an upfront clarification on how to apply the rules to these specific facts and circumstances. It's something that there's no precedent. Basically, something that has not been implemented till now, and is quite difficult to evaluate if it's working or not. Again, as I said, companies must put in place appropriate system and process in order to be able to identify, track, and trace the qualified IPRs, and a proper record of all the information must be kept by the company. Otherwise, it's going to be difficult for each and every entities to even apply. I'm not talking about getting the incentive, but apply for it. Well, this is basically it. It seems to me that we are almost running out of time. Just for letting you know, even China and Vietnam has tax allowance and grant in connection with R&D and IP. And I mean, I'll be happy to put you in touch with my colleagues in this jurisdiction if you have any queries and address your questions. Well, thank you very much.
Thank you, Marta. Thank you for your contribution as well. And I don't see Michele anymore. Maybe.
I'm here.
Oh, okay. Yeah, sorry, because usually I see all of you, but I couldn't see you. Okay, perfect. Okay, so let's just start with a couple of questions. We still have 5 minutes to reply, I think, to the last two questions that I see here. So the first one says, given the expansion of the e-commerce businesses, how can we protect our brand considering the cross-border selling? Who would like to take this question? Okay, please, Michele, go ahead.
Yeah, as I was saying, every platform has got its own system to stop and close the link selling counterfeiting products. So the rights owner that find someone selling counterfeiting products using the brand, they can write to the platform on different system, mention that there is someone, a link selling counterfeiting products, and if the rights owner has got the chance to send all the information about the ownership of the brand. So first of all, the trademark has to be registered, because this is another problem. Often the companies would like to protect their rights, but they don't register it. So this is the first step in order to claim protection. So if your rights are not registered, it's very difficult to claim protection. So once you have a trademark register, you send to the platform, and the platform will take down the link. This is the most simple and fastest way. Of course, I cannot now detail every platform system because we don't have time. And in particular, if it's in particular cases where the violation is important and deserve a proper strategy to combat the sale in internet of the goods, I mean, as used to happen in the physical market, we can strategize the collecting evidences, notarized evidences, and start the proper action out, I mean, in court or with administrative action, or even a criminal action. We successfully managed to run criminal action through the information and the evidence collected on the platform. Because some platforms also give you the record of sale, so we could show the police the record of sale. So although they were not physical products, the police start an investigation, found the responsible people, and start a criminal action against the responsible people. So it is possible. In particular, in China, internet is extremely under control, and they got a lot of system to stop the sale of infringing products. China has also shifted on the platform the responsibility of the sale of the counterfeiting products, and compared to other countries like United States and Europe, the responsibility on the platform is more important, so that the rights owner can always get involved. Of course, as I say, trademark register, clear-cut violation, because if it will look alike or similar, this is not, I mean, you can collect evidence on internet, but after you have to go to court and discuss with the judge and make understand the judge that there are violation of your rights. So I hope.
Yeah, I think it was quite exhaustive. Thank you, Michele. And then the other question, it says, what industries are most affected by threats to intellectual property? Can you do a parallelism between China, Singapore, and Vietnam? I think, Michele, this is also addressed to you, since you were doing the presentation on the 3 countries mentioned here.
First question. Well, it's not easy to answer, because affected on what perspective, what point of view. But let's imagine the most visible, the volume of business, and probably is the luxury industry. That is the easiest one to be. But honestly, the food industry has got a huge problem. So big multinational company, they got a lot of problem for infringing products for food, automotive, pharmaceutical, and many other. And this, I mean, where maybe luxury industry generally it does not present a risk for the consumer, or a straightforward risk for the consumer. If we're talking about food, medicine, and automotive, of course, we can understand this is very, very bad. So probably in this relation, they gain, let's say, importance on other kind of counterfeiting for this reason. But probably the luxury industry is affected most important. The parallelism between China, Singapore, and Vietnam, no. The reason, because there are very different countries, and I mean, China traditionally is a producer and very strong and very big internal market, where the Chinese authority, the central level, did an amazing job in the last 20 years to combat the IP. Vietnam probably is a country that's developing more recently, more maybe you have to be more focused on the production of products, and Singapore, I think, I mean, if you're talking about counterfeiting on low level, probably is a more checking, a custom activity to check the port. And as Marta was saying, after, if not, we go higher level of you know, disputes in the arbitration center or the Singapore court, but this probably is less, is like company to company, not owner against infringer. So they are very different, and it's very important from the registration level up to the enforcement, and create for each country its own strategy in order to get the best results possible in every country, and of course have the best return over the investment.
Thank you, Michele. I don't think there are any more questions, but just in the meantime, I would like to remind everyone that we have recorded the session today. So if you would like to rewatch it or even read the PPT of our speakers, you can do so by going and visiting the ICCS website under the video gallery, and also the past events. Actually, also our time is up. So if there are no other questions, then I would like to thank again Michele and Marta for joining us today, for giving us this opportunity.
Thank you very much.
And of course, the company, so Ferrante Intellectual Property and Fidinam, for making this possible today. Thank you, and also thank you to the guests once again for joining us and listening to today's speakers. Yes. Thank you.
Thank you very much, everyone.
Thank you very much. Good evening, everybody. Bye.
Thank you.
Bye.
Bye.
Michele. Bye.